We now go to criminal defense attorney Bob Bianchi with more on this verdict. Bob, thanks for joining us. It's great to see you.
Great to see you.
So there's a lot of misleading headlines going on about this. A jury found Trump liable for battery and defamation in a civil trial, though he still denies their allegations. Now, I also have a hard time believing Trump truly received a fair trial. But what are your thoughts on this case, Bob?
Well, I'll take Trump out of it for a moment, the personality, excuse me, of Donald Trump. The trial was tried before a judge who's very well regarded. The judge actually bent over backwards and gave courtesies and leniency for Trump to even come in after the defense had completed its case. That's an accommodation that is not made often by a judge. So I think the judge is going to be pretty sound on the law. There was one issue that I found interesting that could come back on an appeal. But listen, I mean, we get to a place now in the last 7 or 8 years where we talk about every trial being unfair. There were 9 jurors. It was a unanimous verdict. Whether you like the verdict or don't like the verdict, it will have an opportunity to have an appeal. But not every trial is unfair because you don't like the outcome or the result. So, I mean, I saw one thing, if you want me to talk about that, that I felt was not fair to Donald Trump in the case, and that could be a basis for appeal. I'm not sure how far it would go with an appellate court, but you let me know if you want me to talk about it.
Yeah, go for it. I'd love to hear it.
Yeah, but there was a lot made about the fact that he didn't show up for the trial. And you do not have to show up for your trial. You have a right not to. It's not good not to show up for your trial because it's a bad look before the jury. And you may even be able to comment on the fact that the person didn't show up for trial. But I felt that it was emphasized to such a level that you have to remember that when evidence comes into a courtroom, it has to be relevant. And relevant means that it tends to prove or disprove an element of what what the case is about. And the fact that he didn't show up there, which was his right to do it, again, I felt was just hammered to such an extent that it really was appealing to the emotional pieces to the jury as opposed to something that tends to prove or disprove an element of the civil case that was brought. So I saw that as being problematic. I was surprised the judge let it go to that level. But on appeal, remember, it's not a redo. The appeal is the court's looking at it to say, was there a violation? Did the judge make a mistake on purpose, accidentally, whatever it may be? But moreover, you have to go over another hurdle. You have to show that that would have palpably changed the outcome of the result. And so if I were appealing for Donald Trump, I'd be appealing on that issue that it unfairly attacked him for something that he had a right to do. It was emphasized over and over and over again, and it tended to prejudice the jury. So that's where I see an out. Most legal experts that will be opining about this will tell you that if it was an error, it will be an error that the appellate courts will overlook because they will say that it was the deposition and her testimony and the deposition that corroborated her testimony that were the important factors in the case. We'll have to wait to see.
Very interesting. It'll be great to see how that one pans out. We'll be staying tuned to that one. Now, Tiger Woods is getting a very strange blast from the past. This is kind of a weird lawsuit, but I know you have more info on it. Can you shed some light on what's going on this one?
Well, apparently he's dating this woman for a number of years. I'm not a Tiger Woods follower, but from the articles that I read, and they broke up. And he essentially, I think there's a lot of bad feelings, hurt feelings in the manner in which it was done. At some point in time, there was an NDA, a non-disclosure agreement, that was Tiger Woods, she claims, forced her to sign. And she basically is saying that, well, we had an oral contract that I would be allowed to live in his $54 million estate for 11 years. And he basically gave me the bum's rush out. He put me on a plane, ostensibly that we were going on a vacation. And when I took off, I'm not knowing it, he broke up with me through his lawyer, and I was not allowed back on the estate. So this lawsuit's got non-disclosure agreement issues, which she said was fraudulent. She wants that non-disclosure agreement to be thrown out. And I guess she wants some rights to be able to go back to the property and some damages. I don't see this lawsuit in a million years. If that were true, people like me, you, and everyone else in the world that has a bad breakup would be liable for damages because somebody doesn't like the fact that somebody broke up with them. I don't see the suit.
Well, I guess that would be a smart move if we could get away with it, but we'll see how it all ends up. Now, Sam Bankman-Fried, the FTX founder, has asked a federal court in Manhattan to dismiss criminal charges against him. And as we recall, his cryptocurrency exchange company collapsed and customers lost millions. Bob, do you have any updates on this case? And does Sam have a chance to have the criminal charges dismissed?
In a short answer, no. So I could end there, but let's go further. So in this case, you have to remember that before anybody gets arrested, there has to be an establishment of probable cause. That means it's likely that you have committed a crime. So there's already been a judicial finding that the facts that were presented by the prosecutors established probable cause to believe a crime was committed. Now, in this particular case, one of the arguments that the investors are making in part of the crime and the wire fraud and all the other offenses emanates out of the idea that those funds that were being given to him were supposed to be used for a sole purpose, but rather what they were being used for was to actually fund a sister company, unbeknownst to them, that was making risky investments that eventually went under. When it went under, he wasn't capitalized, and the whole thing just spiraled completely out of control. That clearly is going to make a factual argument for fraud and wire fraud and things of that nature. So while the defense will try to file motions, and remember, that's what lawyers do, they file motions, I tend to want to file motions that I believe I can win for my credibility before the
Agree with you there. Now, last case for your commentary, the U.S. Virgin Islands is suing the estate of Jeffrey Epstein, alleging he abused underage girls at his private island. The lawsuit claims that the co-founder of Google, Larry Page, had visited many times and had extensive interactions with Epstein. And the U.S. Virgin Island government is trying to serve Larry Page, but apparently are having a very hard time locating him. Is this within his right, or should he be compelled to cooperate with the investigation, and how does this ultimately reflect on his character?
Well, I'm a rule of law guy. Listen, if we don't allow, and I know people it's frustrating in the last, number of years where institutionally people are against, the institutions that keep our society together. Now, don't get me wrong. I have made many arguments for many years that law enforcement officers, prosecutors have done the wrong thing. And when I was a prosecutor, I tried very hard to make sure we did things by the book. But that can be addressed down the road. Look, the law is that if you are in an investigation and they're trying to serve you a subpoena and you're dodging that subpoena, you're not complying with the law. I guess you can run, but you can't hide, because ultimately what's happening here is the Virgin Island authorities are going to the Second Circuit, or in Manhattan rather, or I think it's in Manhattan, but in New York. And they're essentially saying, Judge, look, we have done everything possible to serve this. We can't find him. And we're asking you to allow us to serve it on his company. I believe it's called Alphabet Inc., which is the parent company to Google, and allow that to be proper service. So from that standpoint forward, if the judge permits that, and he does not have personal service, but the judge allows the company to be served, then he'll be responsible and liable and potentially in contempt of court for any subpoenas that he does not respond to. What does it look like? Well, let me tell you, as a former prosecutor, I got somebody dodging. It makes it look like there's a reason they're dodging. Flight or running from law enforcement or running from lawful process is evidence or consciousness of guilt, they call it. And secondly, it has a tendency, excuse the expression, to piss prosecutors off.
Yeah, absolutely. It definitely sounds suspicious to me. Well, Bob, thank you so much for weighing in today. We always appreciate having you. Where can people go to find you and follow you for more?
Okay, always my pleasure. You can find me at rbianchiesq. Thank you.
Thanks, Bob.